All right, let us begin. Good evening, everyone. Welcome to the, what is it? April 2025 meeting of the Racial Disparities in the Criminal and Juvenile Justice Systems Advisory Panel. Again, we have a very full agenda. You've seen it certainly. So I'm going to ask that we're not going to do the Hollywood Squares thing again. If you speak, please announce yourself at that point, name, affiliation, pronouns, whatever you need. Please do that then. But otherwise, let's keep going. As far as announcements go, um, I don't think that, oh, yes, I do have one actually, and I need to put Sheila on sort of center stage here. There are, before the public commentary, I have comments on the next biennial report. That can easily wait until next month. There's no problem with that. Sheila, do you want to talk about what you wrote us all about?
Right now, or would you like
No,
me
no,
to
no.
talk?
When we get to that point,
Oh,
after
okay.
Todd and then before the public commentary. Do you want to do that?
Yeah, that sounds great. Thank you.
Great, you're welcome. So we're going to shelve that until the comments on the next biennial report until May. And then we're going to do, Sheila's going to talk a bit about recent events involving the Agency of Education. Uh, that's all I've got. Anybody else? That's looking like a no to me. Okay. Um, let's begin with the discussion of the proposed legislation regarding equity impact assessments. I got this wrong. I put there this may require a vote, but that had to do with a perception that I had that was incorrect. There is not really a vote, I don't think, that needs to be taken. It would be nice to know where that legislation is right now. What I was given to understand was that I guess we were calling it a briefing sheet that the legislative subcommittee put together was what we were going to be giving to Representative Arsenault. Am I still correct about that? Hello? That was a question.
Sorry, I just showed up. What was the question?
Oh, okay. Hi, Suzanne. I'm sorry, I didn't see you. Hi.
Hello.
The regarding the equity impact assessment legislation, I got it wrong, I think. And I think what the plan was, Todd was reminding me, was that we were simply going to take that briefing sheet that you had written and that was what we were going to hand to Representative Arsenault and she would go from there. Is that everyone else's assessment?
Yes.
Susanna, do you remember that as well?
Yeah, that's what we talked about at the last full meeting. And then since then, we had a meeting with the representative and just
Oh,
confirmed that she had what she needed. And I believe she said she was taking it from there and was going to present it to Ledge Council.
oh, great. Thank you for that. That just needed to know that. Thank you. All right. So that's going and it's out of our hand. Oh, Rebecca.
Susanna, a question for you. Did you get a sense from Representative Arsenault that the hope was still to get that introduced this session, or do you not know?
No, the sense that I got was that she didn't expect it to be introduced until next year.
Okay.
Thank you.
Todd, am I remembering that correctly?
Sorry, I'm in the process of trying to get the minutes to catch everybody who's here. Somehow very tricky for me to get the members and the guests, but I think I got it. Yes, I think you're totally right. Though I'm not positive, there may be a chance that it gets technically introduced on the floor this year,
Okay.
but it won't be taken up until next year, or it is unlikely to be taken up.
Which is pretty much what we expected would happen.
Yeah,
So.
and I think Rep. Arsenault, she has a conflict now but anticipates being here between 6:30 and 7. I saw her like half an hour ago.
Okay. Okay. Um, then I guess that's all that needed to be known, and I should have known that, and I didn't, and I made a whole agenda item for it. Sorry. Um, I at least we're all clear on where it's at right now, and it's out of our hands, and it is going where it needs to go, unless we hear otherwise. So thank you. And again, a really huge thank you to the legislation subcommittee and all the work that you all did on putting that together. Thank you enormously. Um, I'm particularly obsessed with this one, partly because of what happened with this panel and the legislature last session. So this has become a kind of idée fixe for me. So if I get too annoying, just let me know. And then next is the presentation of the Division of Racial Justice Statistics, with, I gather, help from the Office of Racial Equity. And take it away.
All right, thank you. Yeah, I'll just tee it up. So, you all know that we and the RDAP are doing our best to keep up with legislative things. There's a lot that moves on in the legislature related to these topics at all times. And we are watching bills anyway, so we figure bringing back info here is easy enough to do. So as agreed by this group, the staff has put together a small collection / review of bills that are currently pending in the legislature that are relevant to this group's work. I'm going to pass this off to Laura and to Angela to walk us through them.
Laura's yours, guys.
Sorry.
It's
Um,
okay.
I don't know if I have permission to share, so that's what I think I do now. Thanks, Todd. I appreciate you.
Hey,
Todd, you're
Laura,
the smart
can I-
one.
Laura, can I ask you that when you share, if it's possible, if you can make things larger? I noticed the last time we had a presentation, and I apologize, everybody, I'll get glasses eventually. But some things are hard to read. If you could just be mindful of that, if there's ways to increase that in any slides, cool. If not, then my comment's a moot point.
Okay, I will do my best, and I will also say that later in the presentation, we talk about a bill mapping project, and that is something that Aton sent out a few weeks prior to this meeting. So y'all should have that Excel spreadsheet too, if you want to pull it up and follow along. And if you can't find it or you don't have it, we can follow up after this meeting. And I also want to say that Angel and I updated some of these slides because, as all of you know, the legislature moves really quickly. So one of the bills that we're talking about is already an act. Because we didn't do Hollywood Squares at the beginning, and Angela, this is her first meeting, I just want to give her an opportunity to introduce herself and kind of say a little bit about what she does for the office.
Buenas casi noches. Hi, everybody. My name is Angela, but I'm not from here. I'm from Colombia, so I speak Spanish, and the real pronunciation of my name is Angela. I use she, her, ella pronouns, and I am the policy person at the Office of Racial Equity. So, yep.
Okay.
That's it. Happy to be here.
Sorry, I forgot you hadn't been here before. I would have done a better job of introducing you.
You probably would have done a better job than I did. So I don't know if Tiffany has anything to add quickly before we jump in, and then I promise I will actually start the presentation.
Hey, I'm here. Thank you. No, I don't have much to add. I think Laura and Angela, you've done a beautiful job putting together this information, and I think it would be tremendously helpful, I think, to RDAP and to us as we start to follow bills and hopefully be of support to this group. So no, I don't have anything to add.
Okay, great. Let's get started. So as we discussed already, this is going to be about pending legislation related to the criminal and juvenile justice systems, and Angela and I worked on this together, and also incorporated some upstream factors. So first, we're going to talk about the bills that we have discussed previously in this panel, and then a few others that were mentioned last month, I believe, by Reverend Hughes, and a few others that we've been paying attention to that have come up. Secondly, we're going to discuss the ORE and DRGS bill mapping project. Third, areas of further research and focus. So consider this kind of also an update from the DRJS on things that we're interested in working on. And again, Tiffany can speak more to that at the end of the presentation, which will also include next steps for RDAP, and Susanna will take over from there essentially. So first, we're going to discuss with you pending legislation, like I mentioned, criminal and juvenile justice systems, as well as the upstream factors. Sheila, is this good? Is this good?
This is fine, and thank you. I realize that I do have the document and I can look at it that way, and this is a great, thank you.
Cool, just want to make sure. So, yeah, no problem. So Angela and I made a chart, when Susanna kind of put it all together in this way of the bills that we're going to be talking about, and if they crossed over and whether or not we have equity concerns. So the first one we're going to be discussing is H2, which is about raising the minimum age. It did cross over and we did have equity concerns, and that is the bill that has been signed into law, so that's been enacted. S12 about sealing criminal history records, H118 or S19 about the hate motivated crimes. And Todd, if you want to speak more to that when we get there, please feel free to jump in. And that goes with any of you too, who have been maybe testifying on these or following even more closely. S9 related to access to orders against sexual assault. H410, I know that recently came up regarding calculation of recidivism. I believe they're taking more testimony on that this Friday. H32 related to opioid use disorder treatment in correctional facilities. H357 relating to the Office of Racial Equity. H361 regarding municipal and civilian oversight of law enforcement. H382 relating to data collection in the criminal justice system, which we've also talked about in this panel. And then H409 relating to bail revocation. Okay.
Laura?
I'm seeing Eitan with a hand.
Yeah.
I noticed that H357, an act relating to the Office of Racial Equity, doesn't have equity concerns. I'm just a little confused, I guess.
We are too. It's a short form bill and there's no detail. It proposes to make the Office of Racial Equity independent of the executive branch. That in itself, certainly we could identify some equity implications, but being that it's a short form and gives no other information, we're holding review and analysis until there's more meat to it.
Okay, thank you. Sorry.
That's okay. Right to pause. Okay, so I'm gonna talk more to you guys. So first we have H2, which is an act relating to raising the minimum age of delinquency, which is now Act 4 of 2025. The governor signed this into law on the 31st. And so I know Tyler Allen has told us so much about this. And if I miss anything, please jump in. But this essentially increases the minimum age to 12 and pauses the raise the age rollout of implementing 19 and 20-year-olds until 2027. I believe it also adds an additional report for the Agency of Human Services. Our equity concerns were addressed based on this new version of the bill. We had some concerns about the expansion of juvenile probation. Excuse me. And I think we feel that this bill could push further with 14-year-olds maybe being more of the age that we see around New England, but 12 being better than 10 as it was, I guess. Anything else you want to add, Tyler, before I move forward?
Not too much. I guess my understanding of New England when the RDAP wrestled with this issue last year, bringing up to the age of 12 brings us largely into conformity with New England. I do think there's one other state that has 13 with carve-outs, but generally speaking, it's a little bit closer. I do know we had asked, the RDAP had requested the potential of an exploration into what 14 could look like. And I don't think that this bill stands in the way of that at all. I still think that that's good work to be done. And then the only small thing I'd add is they put in the expansion of jurisdiction for 1 additional year on the long end of it. So if is that the part you're talking about, Laura, where if you have somebody at the age 19, that their the juvenile jurisdiction would end based on when their case end, this extended it up to 20, so to speak. And it did that in kind of all the areas. And we actually testified to this, DCF did a little bit, thinking that there likely wasn't going to be too much of an impact on it. That was an attempt to give individuals the opportunity to complete, for example, treatment. If they were compliant with their terms of juvenile probation, it would give them some more time, so to speak. But it doesn't necessarily at a case level extend everybody's probation. It just extends the opportunity for juvenile jurisdiction to go longer should it be needed. So I just want to provide that clarity for folks. But other than that, I really do appreciate this is a good summary of what the bill holds.
Thank you. Thank you. The next one we have is H32, an act relating to treatment for opioid use disorder in correctional facilities. And so this would provide medication for folks who are currently incarcerated that have opioid use disorder as a continuity of care method for when they are no longer incarcerated. Our current equity concerns with this bill is the inconsistency in language in the terminology between inmate and offender because it captures different population. They also identify detainee, excuse me. But again, I'm losing the word, but mixing up inmate and offender kind of impacts different populations. So that's a concern that we have. We also know that it's not really going to move forward likely until the 2026 half of the session, but again, just something that we want to keep our eye on to make sure that there is continuity of language and that we're actually addressing the population that this is intended for and doing justice by them. I think this is you, Angela.
Then we have H118 or S19, and this one expands the scope of hate-motivated crimes. The office supports this bill, and we testified about it because it makes a good shift towards a more person-centric terminology, which we welcome. However, our concern is that this bill is not going to stop hate crimes to happen. So we do believe this is one step in a long line of steps that need to be taken in order to prevent those hate-motivated crimes. So yeah, it passed House and now it's in the Senate. Maybe Todd, would you like to add something else?
I really don't have anything to add to that. We talked about it a little bit. Have you been invited? They wanted to make sure ORE had a chance to testify in Senate.
Yeah, in the Senate again.
Yeah, great.
And
I think
it's on. Oh, go ahead.
It doesn't. I think all signs point to it passing out of the Senate. Would completely agree. It is a small step, and it's not going to get us where public education and further growth and development will get us on hate crimes.
Could
I saw your hand, Eitan. Oh, go ahead.
I just am curious about the other steps, Angela, that you were mentioning. What do those look like? Is there a timeline for them? Partly because I just want to get a grasp on what the panel perhaps should be doing before this moves, if anything. Okay, that was not a fair question.
I don't have a quick answer to that, but and actually we were talking about it with Susanna today in the office, like the fact that our office goal or statement or purpose is to dismantle racism. That's huge. And
yes.
that's like we need to do a lot of things, and we are not able to do it on our own. Like it's not only our mandate, or yeah, it's very hard to do it only alone. And that's why I appreciate this space, because there are more people interested in doing it. But I would say the bill is a good one, but it's not enough. And I do believe we will, I personally believe we need to be having conversations around gun and gun prevention violence in this country. I am from a different country, so to me it's wild what happens here with mass shootings and stuff. And maybe for some Americans, this kind of violence has been normalized. But to me, because I'm a stranger, I'm like, what is going on here in this country? So I think we need to be having those conversations about gun prevention and parallel conversations about white supremacy, which is super ingrained in this culture. Yeah.
Okay, thanks. I just wanted to, I know I'm boring, but I just wanted to get that sort of sense of where we might need to be going with this right now. But it sounds like this is where we need to be going right now. So, okay, thank you. Go ahead. I'm sorry.
Nope. You're
Okay,
okay.
feel free to jump in, and everybody else in the room. Now we have AS9, which is an act relating to after hours access to orders against sexual assault. So this one basically allows people to request emergency protection orders against sexual assault when the court is closed. It has passed Senate Judiciary and is now in House Judiciary. So it's key. It's a good one, in my opinion. And then we have S12, which Laura can talk more about it.
Thanks. So S12 is an act relating to sealing criminal history records. I know that the Defender General's office did a lot of testimony on this. So Rebecca, if you have anything additional to add, please feel free. But basically, this establishes a robust sealing regime for criminal history records, which is, I believe, part of one of the governor's main initiatives is moving towards sealing versus expungement. It basically holistically removes expungement. I think there's maybe one exception, which I can't think of the name of the program. I'm so sorry. We did have equity concerns with this. I don't think it made it into the bill this way, but there was a 10-year period of access, which they also called super sealing, that I know was discussed a lot, and that raised a lot of red flags for us because it basically gave everybody and their mom, as far as state government entities, access to electronic criminal history records for that 10-year period of time, with additional parameters of access post that period of time, without a management strategy in place, because obviously there's going to be an increase in digital records that we're creating records in a digital environment, which is another concern that we had, was perpetuating digital punishment, especially depending on what access to these sealed criminal history records look like. It passed Senate Judiciary and it's now in House Judiciary. I haven't seen any testimony. And again, Rebecca, I don't know if you know any more about that.
Hi, Rebecca Turner. I forgot to introduce myself earlier. Head of the Appellate Division and part of the legislative team at the Defender General's office. This isn't the bill I'm tracking. Marshall Paul is doing this for our office. So I'm sorry I don't have the details as to what I understand to be the next up in terms of testimony and things. I would say that of all the bills that you are talking about today and listing, S12 for us has one of the highest concerns for equity and serious implications, particularly because of how far along down we are to close passage. And I would hope that this panel, if we can weigh in as a panel on treading carefully, and also to ask the questions. Have you considered how this will have and play disproportionately on people who have been historically disadvantaged in the criminal justice system? Fundamentally, this is about dropping expungement and replacing it with a sealing scheme. This is backwards thinking from the rest of the country. When you expunge a criminal record, it's gone. When it's sealed, it's still accessible and can be used by a great broad definition in this bill of who can access it. It's not just who you think, but it's law enforcement plus. And so if you think about how racism is baked into our criminal proceedings generally, and how we have a current situation of expungement that will be replaced by a mere ceiling that is absolutely not protective. And so I urge this, and I have a couple others that didn't hit, one other that didn't hit your list, and then the bail revocation I'd like to talk about later, but I'll
I
stop
was
there.
definitely hoping that you would, because I know that you testified on it a week or so ago. Thank you for that. And I see Eitan, your hand, yes.
Yeah, I had a question for Rebecca, and then I started listening to everything else, and now I can't remember what I was asking. I
If it comes back, we do talk about this a little bit in our areas of research and focus, because we've done a lot of work on sealing and clean slate and those kinds of reform efforts.
Well, and we may get a chance to testify on this one if it has gone into House Judiciary, because that's Martin Lalonde.
Mhm.
And as he was one of our friends as for the panel, and he is more likely, I guess, I would say, than any of these other players to in fact ask us to testify.
Yes, I'm
That's
hoping so too. And I know Susanna and I were able to testify in the Senate. So and then I know we discussed a little bit about H 357 when we were running down that checklist. Like Susanna mentioned, essentially it's a short form bill right now, so it makes the Office of Racial Equity an independent office, and it's currently in House Government Operations and Military Affairs. Sorry, my computer keeps.
Does ORE becoming independent, this is probably the stupidest question on earth, mean that you get more funding and maybe some more people?
Likely less of both.
Oh, that's lovely. Thank you.
It all boils down, and our friends at agencies like the HRC and other quasi-independent agencies could probably express this better than we could, but it likely comes down to proximity to power at the earliest stages of the budgeting process. And where you're nested matters very much in terms of where you're starting from.
Okay. Okay. Thank you.
Oh, sorry. Is this you, Angela?
So basically, this one, H361, creates a community police oversight board, is in-house GovOps right now, and we haven't heard testimony yet. So I think we'll be waiting for that maybe next session. And then H382, yeah, go ahead.
Yes,
I know, I'm like filled with questions.
The
Community Police Oversight Board actually have teeth, or is this yet another advisory panel?
Good question. What I have written down here is that a board's investigation is in addition to the investigation that may be conducted by a law enforcement agency and the Vermont Criminal Justice Council.
Okay. All right.
But I don't sure.
I'm also curious. I don't know. Is the way that today's meeting set up? We can't raise our hands and all that stuff. I just
No,
wanted
go
to-
ahead, Sheila.
Yeah,
I
no,
can't see
please.
everybody.
Because no, but the raise your hand button isn't working for me. So but it just so happens that you, Rebecca, everybody has said the comments that I've wanted to say, so it worked out here. But I'm gonna have to maybe just jump in because
Yeah.
my things were working. But police oversight, I'm just wondering, what is the template? What can you say more about creates a community? Can you say more? Is there a template they're using? Because I ask these questions because we have what we call the CPCC here, and I used to be on, which was supposed to be an oversight of the police. And many of us know that these were more advisory and just made us work for nothing, and this had no teeth. And so that's a really valid questions. But I'm wondering what the model is. Who, if anybody, are we taking a model from? Because Vermont clearly hasn't supposedly had the model that's effective and brings equity and does what at least many groups over the years that I've been involved in. So I'm kind of curious if we were doing the background work and seeing other models from out of state or if in state, or we don't have a model at all, or can you say more about this bill?
We're really lucky to have the bill sponsor on the call right now.
Great.
Yeah, Coach, I don't know if you'd like to say anything.
Hey, Coach.
Hello.
Hello. Would you like to weigh in at all on H382?
Coach, I was specifically asking if this, in creating the Community Police Oversight Board, if there's any models
Oh.
that you're using to
Sorry.
create this.
Well, I think what we would be doing is relying, on the testimony that we've taken over the last, 2 bienniums and build on that to create, that body. The models that we would probably, look to, are things that that work in other areas of responsibility as far as regionalizing, those entities, because one for the whole state might make sense, but at the same time, we know with the way that justice is accessed here in Vermont in 13 different ways, I think the more responsive approach would be towards, having regional, kind of like the environmental boards type of approach.
Great.
If
Thank
that
you,
helps.
Coach.
Thank you. So I think the answer is there isn't a current model. This is future. So you'll be looking into various different things, but you don't have a current model that's being represented right now for this bill.
I did put the bill language in the chat, Sheila, if you want to take a look at it. And it looks primarily to be entirely new language, so.
Okay, thank you.
No problem. Are there any other questions? Okay. We've talked about this bill a lot in this panel as well. I know Grace Ahmed is on the call. I don't know if she wants to comment on this. H382, which is an act relating to data collection in the criminal justice system, or also the Vermont Justice Transparency Act, which requires various state criminal justice agencies to collect and publicly share detailed data about the criminal justice system and their place in that. It's currently with House Judiciary. We're thinking that it'll probably likely move in the 2026 part of the session, and we're hoping to be able to work on some language with the folks who are sponsoring this bill. And Grace, if you want to add anything, please feel free.
Sure. So the RJSAC endorsed this the last time that we met, with a couple of like concerns and caveats expressed. One is just a concern about the aggregated racial data in the national climate, and then concerns about consensus on the semantics of like what exactly these things are. So I sent Eitan, I sent you a spreadsheet that's kind of a breakdown of all the different things that are in the bill, if you want to share that with folks at some point.
I would be glad to, and I'm ashamed to say I don't remember where it is in my email, but I'll find it.
Okay. It should be from grace.ahmed@gmail. And that was just a breakdown. That's like that was done by Pat Otilio, that's with the Racial Justice Alliance. And he just kind of like went through the bill, and so it's a layperson's like reading of that bill, not a lawyer's. Just so we know what that spreadsheet is. But And then the consensus on semantics. And so it's like it's a conversation that we'd like to have more on how we're the process to reach that consensus on, so everybody knows what we're collecting to make that data really usable both for the public and for the division, for the RJSAC, for whoever is using those numbers, to like, if we define some of those semantics ahead of time, it may prevent some problems downstream of like, what does this thing actually mean? You know, even as far as like data dictionaries and putting some of the requirements of semantics or the process to arrive at those, maybe could be language that we could look at further.
I do have a question.
Okay.
When we put together the how many 3 reports to get the Division of Racial Justice Statistics up and going, I remember and some of you may also recall, it was a nightmare trying to find all of the data that we needed. It was siloed in simply just to a level that is just weirdly unhealthy. And you'll remember we were making jokes about putting together a time. Whoever's got talk going on in the background, could they please mute themselves?
Maybe the host can also do it.
That's right. I forget that.
Representative, there you go.
It was so siloed, and we made jokes about creating a time capsule up on Camel's Hump so that at least we finally had all this data in one place and we knew where it was. And it took us the better part of a year to get it, you'll remember. And we had the help of the crime research group with that as well. I guess I'm concerned because I read this and I'm like, well, we were told, remember, perhaps, this can't happen because everyone's got a different data system. To get everyone on the same system is an expense that is simply beyond the state's ken. So I guess I'm just sort of wondering how those problems that were made so present 2 years ago are being dealt with in this particular bill now.
I guess I don't understand that as a data engineer. I'm sorry, like
Okay.
this is not me as like RJSAC. This is me as me. Like I have a master's in data science. There's not, once those, if the data is reported out to a place, like all of that's not an issue. That's like an imaginary issue as far as I'm concerned.
Okay.
Right? If we say we want this data, we want it in this format, we want it to be an integer, we want this to be a whatever, we want this to be, we say what it is, they report it, they send it to somewhere that can host that. That's not a huge expense. I mean,
Okay.
I know bureaucracy can spend money, but like in reality, that's not.
Thank you. I'm glad to know that because that was those who were here when we were doing that, that was a major thing that was thrown at us.
Well, it's a great realistic thing to think about on pushback that's going to happen, right? Because like a couple meetings back, we were hearing from a judge about like, oh, this field is missing often, and when we asked, can they make it required? They said, well, that'll cost $50,000. Like that's also like that's silly stuff.
Okay. I love hearing that. Thank you.
And like you can make things cost money, but
why? Yes.
why? Yeah. Sometimes, but why? Yeah.
Thank you, Grace.
Sure thing.
Anybody else?
Oh yeah, please. Anybody else? So next, and I know, Rebecca, you wanted to talk on this, and I believe you're the only person I've seen testify on this bill. So H409, an act relating to the procedures for bail revocation. And currently this is in House Judiciary. I believe it'll also be, we were talking about this being part of the 2026 half of the session, most likely. So go for it.
Oh, thanks, Laura. Actually, before I do, I wanted to just go back to the data collection H382 bill, because like Aitan, it feels like a little bit of a little traumatizing to read something like this come back. And I have not, this is really helpful. This one had not hit my radar, and I just looked at the committee activity, and maybe you guys know more. It looks like it has not been taken up by any committee yet. I can't hear you. Is it H382?
Oh, 382. So Coach Christie is the sponsor, so I think that's just why we had House Judiciary. But yes, it hasn't really moved. That's why we're thinking it'll be more 2026.
Got it. Got it. Great to see. Thanks for putting that on our radar, because it is exactly, as Eitan said, directly relevant to what we've been making recommendations for several years in our report. We point backwards to say, and also we recommend the ones that we made before that haven't been taken up yet. So yeah, I hope we can get invited to the table and get involved in that one when that gets up. If H409, yeah, that also, as Laura and others have already said, didn't make crossover. Highly alarming. If and when it gets traction, I would love to see the panel weigh in. This one has huge racial equity concerns. I think that Robin CRG has some new data that I understand related to pretrial release.
Yes.
And the long and short of it is that I hope that we can get them to talk and share those findings to this panel at some point soon.
Next month they're scheduled.
Oh, fantastic. And then two, it's really, really alarming and unfortunately not a surprise, but the trajectory that we understood the system as in when we looked at it and headed, because there didn't seem to be any corrective measures being taken up, any real reform measures addressing this problem directly is showing itself play out in the data. So here we have H409 proposing or ostensibly codifying what the Vermont Supreme Court has decided in the context of how do we revoke bail once someone has been given it, consistent with the Constitution. These were not new decisions. 2016 and early 90s, for some reason, someone decided that it was time to integrate supposedly those main holdings into our bail statute on how to revoke bail once it's given. But it's completely contrary to those decisions, inconsistent, even though it claims to be consistent, and it falls below the constitutional norms, making it easier to revoke, empowering the court to make the motion in the first instance, which is, breaching impartiality laws, changing how evidence is presented to revoke, allowing the prosecutor to revoke without even a live witness, which is again directly addressed and held the opposite by the Vermont Supreme Court, and then allowing for revoking of bail if there are just sheer violations of conditions of release, again, addressed and answered by the Vermont Supreme Court, that alone isn't enough to revoke bail because of our Vermont Constitution and our right to release on recognizance as the presumptive norm. And this proposal just makes it so much easier to revoke, again, contrary to the Vermont Constitution. That's the law. How does that play out when we already know there's known racial disparities in the bail context, period? I think it's a bad idea to throw and make it even easier to revoke bail, constitutional challenges and problems aside.
Right.
So that one, I just want to make sure we keep track of, get voices heard if traction is had on this one.
And right. And again, House Judiciary will likely ask us, I would suspect.
Yes, I hope. Okay, thank you so much, Rebecca. I really appreciate it. And then I believe this is the last criminal related bill, and then we'll be moving towards the upstream ones that will be more just a kind of a quick run through. So H410, which is an act relating to the calculation of recidivism and other related criminology measures. So this proposes a new definition of recidivism and data tracking requirements to track recidivism. Rep. Arsenal, I see that you're on the call. I don't know if you want to say more about this. I know that it's currently in House Judiciary right now. I believe they're taking more testimony on it at the end of the week. It initially started out in House Corrections and Institutions. I do think I remember hearing in testimony that they still will likely need to weigh in and or review it. But likely this is going to end up in some kind of miscellaneous judicial or general bill.
One of those omnibus things.
That is an excellent summary. As far as that, hi there, this is Representative Angela Arsenault. That is my understanding. It will need to spend some time in corrections because corrections would be responsible for the bulk of the data collection. And I think Chair Lalonde is hoping to get this in the miscellaneous judiciary bill, but that really depends upon unanimous or close to unanimous support from the committee. So we shall see if we get there, if we can get the definition right.
Thank you.
Cool.
Yeah, I think there was, again, in the testimony that I've watched on it, there hasn't been much so far. I believe Marshall Paul testified saying that we could expand even further, but that this was a good start. So we'll see where this goes. Again, I believe that there'll be testimony this weekend, Friday, not this weekend. Okay, Angela, take it away.
Yeah. For the office, it's very important to not only see or focus our attention on criminal-related bills, because from a more holistic perspective, we also need to take into account other criminal stuff that is also happening. So S27 is a good example of that. This is an act relating to medical debt relief, and it will help Vermonters with low income to stop having this medical debt affecting their credit reports. So it's a good one. It's right now in appropriations, and yeah, I think Senator Lyons is the sponsor. H169, it's a very interesting bill because it is sponsored by Lenora Dodge, but it has the community support of migrant justice, and it's basically trying to amend the discrimination that exists in public housing. So it has been getting a lot of testimony. They have been hearing testimony from landlords, banks, people in other states who have implemented this before. So it'll be great if it passes. H91, this one is basically the one who is trying to create a new program called the Vermont Homeless Emergency Assistance and Responsive Transition to Housing Program, or VHART, because it's too long. So this program will replace the General Assistance Program, and it basically is trying to help families or people who are homeless or in risk of homelessness and victims of domestic violence. So they've been spending a lot of time on this bill, and it's right now in the Senate. Other one that is interesting. Oh,
it was House Human Services, right? Is where it started. And now, okay, just wanted to make sure.
Now Senate, yeah. And S56 or H375. This is the one who is creating the Office of New Americans. There has been a lot of discussion on what a New American is, or the definition of New American, but the Vermont Asylum Seeking Project is also supporting the bill, and this will try to support immigrants or asylum-seeking families in the state and will help them to settle in Vermont. The other one is H167, which will establish the Vermonters Feeding Vermonters grant. And it's a good one because the cut to federal funding has affected agriculture and a lot of programs in different ways. So if we can get this program implemented at the Agency of Agriculture, we can try to handle the issue and try to filling in the gaps. And lastly, H24, this is an act relating to basically businesses need to accept cash. So in ORE previous reports, we have mentioned this. It is important that you can pay with cash in different places. So we are really waiting to see what happens with this bill because it will have a good amount of equity implications if it passes.
Yeah.
Not everybody pays with phones. Not everybody has a bank account. That's also a privilege. And yeah, those are some non-criminal related bills, but happy to talk about other ones that are so many.
Right.
We don't want to, spend all the time talking about it. Yeah. Okay.
Go ahead, Sheila.
I was loving some of these when I was reading through them before. Medical debt one, many of them, but I'm very interested in the retail business one. I'm just wondering within that, is there a of what that impact is on the business? And let's say BIPOC owned small business owner, whatever, is there any implications of anything? I know we're currently now, a lot of people charge you for the fees when you use the credit card. So we're paying for those if we don't pay cash. I don't know about you all, but I have a lot of people who do that and are encouraging cash. But I'm just wondering, is there what has been the negatives to this or the counter of this? I'm kind of curious, if any.
Well,
Oh, I'm sorry. Go ahead, Susanna.
Yeah, so this was one of the recommendations that we had in our policy package last year or the year before that. The bill, we hadn't been in contact with the sponsor, so I'm not actually 100% sure, what their trajectory is in terms of how they're envisioning it. But as we understood the issue and when we proposed it, I think that a lot of the pushback that we anticipated getting from the retail sector was going to be threefold. One was going to be, oh, but think about COVID, there's going to be germs. We don't want to pass germs, which frankly, I think is kind of weak when you think about excluding people who are unbanked and underbanked. I don't see that as a good enough reason. The second one is security. Oh, we don't want to carry cash because, we're worried about security. There are lots of places around the state that manage cash and they do fine. And I don't think that you need to have added security. I also think that that's just kind of not convincing enough to warrant, again, going completely cashless and excluding people who are unbanked or underbanked. And then I think the third one is probably just convenience or modernity. There are a lot of places that are particularly new or that cater to a young clientele that are more interested in going cash free. And again, you just have to think about who's being left out. We talked earlier about debt, and one of the things, and we also talked about credit reports, and these things are so interrelated, especially with this group, right? For example, how many people get out after serving time and their credit scores are wrecked because their utilities went unpaid while they were locked up because they didn't have anybody who could deal with that for them. It's one of those things that most of us don't think about when we think about people who are, anyway, I'm rambling, but the point is credit, impact, unbanked, underbanked, access to credit, access to technology, modern payment systems. I don't really see there being more impact on businesses other than things like those fees. But again, those typically get passed to consumers. So it's not clear to me that requiring people to accept cash is going to affect whether or not they're charging more of those fees because they're not incurring more of those fees. I'm sorry if I didn't really answer your question. That felt circular, but
No, you're good, and thank you. And I really like this bill.
I
do you have a question?
I do, which is probably uncomfortable for all of us. Is there the Vermonters Feeding Vermonters grant? So is that really the money for this is coming from the Agency of Agriculture, Food and Markets? I ask because if this money is coming from, how to put this delicately, outside of the state, I'm a little worried. This is the sort of thing that's getting cut right now. And so I'm curious about if funding has been discussed at all. I know generally the legislature doesn't like to discuss that, but these are rather unusual times.
this is a program that has been in existence for a while, actually run by the Vermont Food, if I'm understanding the bill
Right.
correctly, run by the food bank. So I think this would just be, I think that this would just be providing more stable source of state funding to continue it.
Okay. Thank you.
I put something in the chat. I don't know if it's helpful, but it's a presentation that was just given a couple of months ago that kind of runs through it. And I think it was given in connection with the bill proposal. But if anyone has better intel than what I just gave, please feel free to correct me.
Thank you, Susanna.
Yes.
Rebecca.
I was going to put on your radar, as I didn't see you talk about it, a criminal justice related bill that's actually pretty far down the line. It's S87. And so
The extradition bill?
Yes, and I don't mean to take away from other people's questions on these non-criminal related bills, but I'd just like to have a moment to talk about S87.
I will say, Rebecca, even though it's not on the list, I have been following the testimony on that. I know that it's dramatically changed from the Senate to the House, but I'm not sure why it wasn't one of the ones but this was a list of a lot of the ones the panel had talked about. So I'm sorry that I missed it, but please feel free.
Okay, no, and it is. I think it's really hard to track all this. I'm learning a lot listening to your presentation, so thank you. And this is supposed to be what we're doing all the time too. So much. S87, it has changed a lot. It passed Senate, Judiciary, and Senate side. It's now going into for more testimony from witnesses, including, well, I'm here, but I'm actually not here. I'm in California taking care of my family, so I'm not able to go in for the office this week. So, but I know that there is testimony on S87 later this week. It's an extradition bill. Extradition is sort of a whole special scheme, but it overlaps with criminal law and what raises here because the proposal is summary proceedings for a certain group of people who have previously waived their right to extradition proceedings in other states. And extradition is about sort of the formal process of state to state cooperation, where another state is seeking a fugitive who is found here in Vermont. How does a state, because of a sentence, conviction, a pending prosecution, and so that state will, once we find that person in this state and take them into custody, will alert if we know that they're on fugitive status. And so it's this scheme on how do the states cooperate to bring someone who's wanted back to that state. So it's a special complicated area of law, but what's hitting our radar of alarm is that there's a proposal for new summary expedited proceedings that bypasses the normal route of going before a judge, normal route of going and getting an assigned attorney from the public defender's office if they can't afford their own, and lets them go back to the demanding state if they've previously waived their right to extradition proceedings in another state. And so that raises, I think, inherent equity concerns because we don't get into the question of reviewing whether those are actually lawful or on their face until you go before a judge and have an attorney review it. But the proposal here again is to bypass those checks in this special proceeding. The question is, why is that being done? I'm not hearing that this is because other states, there's a tipping point. This is a uniform code, so others follow what other states do. It makes sense in this arena, but this uniform code, this seems to be an outlier position that Vermont is requesting. And there hasn't been a deep dive into the data to look at how long do people sit in our Vermont jails under this special category, waiting for the demand state to come and get them. They're not subject to our protections under the Vermont Constitution with bail and pretrial release, so you can sit there until someone decides to get them. So question again of why and who will this impact the most, and what will this cost Vermonters? In any event, this is, and I don't believe that the committee has heard about equity concerns or racial equity concerns. It just hasn't come up. There hasn't been a lot of data diving into the implications of this bill generally, but I wanted to share this because I think this one is going below the radar, but is moving now into the House Judiciary. So not much time left, but could very well pass before the end of the session.
Is anyone else feeling like Justice Reinvestment 2 was nothing more than a fever dream that we all had? Just curious.
Yeah, we were talking about that recently, actually, in the office. Look, there was a bill, right? And then there suddenly wasn't?
I think so. I also heard, yeah, I heard that there's a lot of things happening that are basically trying to undo all of the efforts of JRI 2. But that could also be something that's swept up in one of those miscellaneous bills. I will say there's S109, which is the Senate Judiciary miscellaneous judiciary bill. I think that's also in the House right now. And there are some things for pause as well, but I know that the House committee is taking new language suggestions and testimony on that. So we'll see how that kind of changes. So yes, there is pause. And I will also say, just as speaking for myself only and not as a member of the DRJS, but a human being, I used to work for the Department of Corrections, and I say this all the time, probably ad nauseum. Morgan Rogers is the extradition specialist for the entire state, and they have not brought her in to testify on this bill. And that gives me pause as well, because she knows, she's been doing that for like 15 years. I mean, she's the one that trains the extradition specialists across the state to do this work. So I really think that is a missed opportunity as well. I don't know, Derek, if you can whisper into someone's ear about that, but.
Can I jump in, Laura?
Yes, absolutely, Todd.
Yeah. So I appreciate Rebecca's point on that, and I think that point was well made in her testimony last week. So the AGO does support this bill because the big concern on this is that absent accepting these waivers from other states, people have to sit through this extremely long bureaucratic process, which can involve them being in Vermont jails for a lot longer, right? To go through this governor's warrant process is extremely long. So we worked really closely with Morgan on the process and with the state's attorneys, and Morgan, I just reminded Martin that she hadn't come in yet, so I think she's gonna be in on Thursday. She also looked at other states' processes to make sure Vermont was like well inside the norm. And we are mainly comfortable with it because it actually should result in people moving out of Vermont custody faster and not waiting on another jurisdiction to take the time to move a petition through their executive branch to bring it to our executive branch, which is essentially what the process is. This is not about adjudication of whether the individual has committed a crime, has fled. It is just about, this is a constitutional issue, right? It's this is one of those few areas of the law where the Constitution speaks directly to this issue. So there's not a ton of wiggle room for Vermont to say, we don't agree with the law in this state, therefore we're not going to extradite someone. But there's a little wiggle room there that we at least want to lean on. In this particular instance, I do think it's important, and Rebecca raises good points about exactly what the data shows. or could show. That said, our understanding from DOC is that by moving the process to accept these pre-signed waivers where somebody says, yes, if I flee the state while I'm on probation, you can bring me back to face my violation of probation, as what happened in Vermont and as Vermont requests from other states. So the goal is to move that process generally faster. And I would also say, for most of these folks, somewhere around 75%, they're released on their own recognizance when they're picked up in Vermont anyway. So we're really looking at the 25% of folks who are held in incarceration and can be held up to 90 days or 120 days awaiting this process to play out.
I would wager there's still a lot here to be discussed.
Yes. Thank you. Thank you for bringing that up, Rebecca, and thank you for adding that, Todd. And again, just as a human person, I think it would be really great to have Morgan Rogers testify on this bill. Anybody that can get her into the State House, please. Okay, so I understand that we've already gone through a lot of the time for the meeting, so I want to be aware of that. I don't want to rush us through, but we'll just do our best, understanding that we only have an hour left. Okay, so what?
And stuff still to go.
And stuff still to go, yes. Okay, so Angela and I are working on a bill mapping project that we're going to be expanding a little bit more this summer. It's based on what I have heard referred to as the arrest flowchart. So it's kind of like the flow of the criminal legal system. It's in the Vermont National Criminal Justice Reform Project report, and that's where it has like the data integration pieces, but this is just kind of the back end to all of that. So we use this as kind of a jumping off point, using these higher bucket identifiers to kind of break the bills that we've been looking at into, and then also incorporating upstream factors. So the upstream factors that Angela identified and that we worked together in putting those bills in include systemic issues of how and why individuals get into prison in the first place, which includes gender-based violence, housing and homelessness, a lack of socioeconomic opportunities, poor mental health and medical health, and food insecurity. So some of the bills that we talked about today touched on those. And then also the criminal justice system, which again, using these as headers, entry into the system, prosecution and pretrial services, adjudication, sentencing, corrections, and then we also added a reintegration category, which you'll see and should be in that spreadsheet that Eitan sent out maybe like a weekish ago. And some of the bills, understandably, would fit into multiple sections within these, depending on obviously what is included in the bill. So we just kind of did our best. And this will be updated when the session is over and we have all of the bills that have passed. But this is kind of what it looks like. I know this is really hard to see, but again, you should have this. And if you don't, I promise I'll circle back at the end. But you can see some of the bills that we talked about today. So here we have prosecution and pretrial services in with H118, which is expanding the scope of pre-motivated crimes or hate-motivated crimes. Sentences and sanctions with H2 are now Act 4. Reintegration, we included H32 because it's about continuity of care post-incarceration, things like that. S9 we have into gender-based violence. We also have the food bill that we talked about, H187 under food insecurities, etc. So what we're hoping to do is take these and kind of map them in this system and then do some kind of tracing backwards of historic legislation that kind of plays into all of these things. So that being said, it leads into, again, this is why I said it's a pseudo half update on what the DRJS is kind of up to. These are areas of further focus and research that we've been working on in the division. And then Angela and I tied those together with the legislative stuff that we talked about today. So a lot of the work and research that we've been doing, thank you, Angela. The look back that we're going to do is from 2020 to 2025. So, and again, we'll be starting that after the session ends. So this summer. So we've been talking a lot about petitionless sealing and this idea of a clean slate. So this is kind of related to the S12 bill about the sealing regime, but mostly related to Act 174 of 2024, which essentially created a working group to identify the benefits of having a petitionless sealing process. Petitionless sealing is not part of S12, and I'm curious to see if it will come up when testimony is taken on that in the House Judiciary. Part of this research is also the digital punishment aspect that we mentioned with with electronic criminal history records. Then we have Raise the Age, which is now Act 4 of 2025. So obviously we have the previous legislation up to the most recent, other than what just passed, Act 125 of 2024. We've also been doing a lot of research on bail reform. This is more of a new area of focus. So we've included H409. Obviously, I know that there have been prior bills in previous sessions. We're looking at alternative responses to policing, so things like H361. And then we're also looking at second look sentencing, which I know there was a subcommittee, which I believe, Rebecca, you were in charge of or part of, for the recommendations that was on second look sentencing in the 2024 report. So we've been kind of doing some looking at that as well. Other things that we didn't tie to legislation, but are also of interest in the division and things that we're working on are small numbers reporting and data suppression. We're finding that a lot in our work, in the data that we're looking at, and then also parental incarceration. Tiffany and I are actually attending a virtual conference right now on parental incarceration, and it's been really incredible. Arizona State University is hosting it. And so let's see. Yeah, so what's next? So I think this is where I stop talking, and now we decide as an RDAP. And Susanna, go.
Yeah, just sum it all up. I know this was long, and again, I think that during session for this group, it would be really good to have standing agenda items so that we could check in about stuff. One of my takeaways from this evening's conversation was a lot of us have new feelings about old bills, and sometimes it is really scary to feel like something is almost at the finish line, and we're just kind of finding out about them. So to the extent that we as a group can think about how to approach next year's session, not that this year's over, obviously we're still focused, but to start thinking about, does something like tonight's review feel right? Is there a way that maybe we can be of service in helping to incorporate this as a regular practice for the group, so that we can all be better coordinated? I know we each have touch points with all of these bills from our own vantage points and our own organizations, but if there's a way that we can be a little bit more aligned or well-oiled in terms of how we talk about them in this room, then that might be helpful. So we, the office/division, remain at your service, and I think that I should cut it there.
I'm gonna stop sharing my screen, but maybe for like the next 2 minutes, we can take questions if you have any, and then we can move on.
Great. Anyone? Oh, there's everybody. Any questions, comments, concerns?
I just wanted to say thank you to the Office of Racial Equity, the data division. This was like super helpful, and I appreciate when things are really visual and colorful and engaging, and that presentation was great, and it just really helped me kind of understand where we are. So I appreciate the time and work that went into it.
I would like to echo that and say this is exactly what we were hoping the division would be able to do when we were proposing this. It was exactly this kind of work, because we can't all, as much as I'd like to hang out on the legislative website, I have a job that I get paid to do, can't do it. So this is really great to have this kind of focus, this kind of thought also with the focus. And I want to thank you all. You have, in a weird way, fulfilled a dream. It's not done yet, but you have done something. Thank you very much. Anything?
Thank you for the time.
Rebecca, go ahead.
I too join in on gratitude. That was a lot. Very helpful. My next question then for the group is what do we do with the information that's relevant for at least this session? I understand that Susanna sort of asked, bigger questions, but I also want us to know that we're still in the middle of a session. We have been invited as a panel to come speak to the legislature. We don't wait to be invited. Or maybe we have generally waited to be invited. I forget, Eitan. I don't know what is the practice. Or now that we have this situation where we are alerted to certain ones, we've just heard summaries of various stages of the bills. Some are going to testimony this week. Some we don't know if they're going to get any time before the session, but we know they've been introduced. So I think that's the question: is does this panel want to take any moves that's not just sitting and waiting for an invite and then an email from Eitan saying, what shall we do? And maybe we decide the next meeting or what. I just wanted to, yeah.
Just put in something that's a little awkward here. You'll notice on the agenda that we're going to go into executive session at the end. It needs to go into executive session. It's a personnel matter. It is not appropriate for it to be beyond legislators and members of the panel. And this issue is going to come up. So I don't want to act like I'm making a Hollywood film. On the other hand, that's it's going to happen. So there's more opportunity to talk this through. Okay. Anything else? All right. Then let's move on. Todd, the floor is yours to talk about on finding a new note taker.
Yeah, I want to be very quick so that we can pivot back to Rebecca's question based on how the executive session may or may not go. So I'm happy. I can either share it with folks or just send it out. But the request had been that this group would be the great group to send out our request for a note taker. So I stopped taking minutes during the meetings. And so I'm happy to just send my very rough draft. I thought if we had time, we could look at it. People could just throw me suggestions in the moment. But I feel like absent real time and not wanting to kind of group draft, what I would prefer to do, unless people feel strongly, is send it out to the panel members. Folks can just give me feedback on the description, and then I'll send a final version hopefully in a week, and people can push that out to their networks in the hopes that we get some folks who are interested in taking on what is a pretty small but pretty cool role.
Okay. Works for me.
Anybody have concerns with that? Okay, I will aim to send that out to the panel members tomorrow.
Great, thank you.
Yeah.
Well, that was quick. Next issue, I have, as you'll remember, said let's not deal with the comments on the next biennial report. And let's go on to Sheila, talking about a very exciting weekend that a lot of us have had, about recent developments in the Agency of Education.
Hey everybody, Sheila Linton, she, her pronouns, panel member and executive director of the Root Social Justice Center. So we all know there's a lot of stuff going on. I can't keep up with everything, but most of you might have noticed that our education system here, well, across the country, is under attack, depending on your point of view. And of course, it came home to Vermont. And Vermont is being asked to adhere to Trump's executive orders, which are many, but this specifically including DEI and other related things of that sort. And so people got the word of this, including the Root, and as we all do in the Root and in the Brattleboro larger community, as we mobilize and we organize. And so I don't know why, did people get the message in the chat? It's not allowing me to press return. I don't, maybe it's I'm over characters or something. But in the email, it's the same thing that I sent in the email, is from what I understand now is that she got the message, meaning our AOE person, Zoe, what's her name? I don't even.
Zoe Saunders.
Yeah, Zoe Saunders got the message loud and clear that no bueno. And so it sounds like she is moving the needle in a different direction. And I do not know the updates. Other people here might know more of an update. Great, Suzanne, I'll let you do that. But regardless, I think that we can still put pressure and we can still advocate. And if we haven't already, I wanted to know if RDAP would be willing to sign on to the letter supporting to not do this that is being sent to her. So that's what it's basically about. If you missed it, individually you can sign on, collectively we can sign on. And, you know, I'm a kind of person who likes to put pressure until pressure is not needed anymore. And so again, just because the needle has moved, it has not moved where it needs to go yet. And I think, and so I would appreciate this panel as well as individuals to take consideration of it. And again, the information's in the email. If for some reason you need that information, again, let me know. Go ahead, Susanna.
Yeah, I think that this one was an example, and I'm talking out of turn here, so wherever this ends up, it ends up. But I think this was just an example of ineffective communication by the agency, because I think that what a lot of people took to be the message was not actually the message. I think a lot of people heard AOE wants everybody to certify that we're on board with all of the anti-equity EOs, when in reality, my understanding is the agency was saying, let's all go ahead and certify that we're in compliance with existing anti-discrimination laws because we're not changing anything. And we read that as being in compliance with existing federal anti-discrimination laws. So I think what was heard was, we're all certifying that we're going to bow to these new decrees. But that wasn't it. Instead, it was, we are legally interpreting everything we've been doing as compliant with federal law, because it has been up to this point, and we're not acknowledging the EOs as new law. But they didn't come out right and say that, because that would clearly signal to Washington that that's the stance. So I think that they did a poor job of communicating to the superintendents that that was it. And instead, they gave a sort of mini communication at the outset and said, then we're going to hold office hours next week to clarify. But between Friday and Monday, it created an entire whirlwind. And without that further clarification, everything spun to the point where I think now this is being viewed as an about face or a walk back, but really it's an overdue clarification that should have come on the front end. That's my assessment. I'm Monday morning quarterbacking here. So I think that at the outset, the agency had given assurances to the district of, you don't have to change anything, we're not changing anything, stay the course. And I think this most recent communication was intended to be more of the same. I don't think they did that effectively. So it sounded like something very different and awful. That's my read. I'm not in the agency. I don't know. And I'm not going to, speak in defense of people in whose minds I cannot be. But from my perch, I'm pretty certain that that's what happened. I don't know if that helps anybody here, but
Sounds a little bit better than before. That sounds better than this weekend. So thank you.
Yeah, and I mean, one of the things that I heard was, well, why isn't Vermont doing what Maine and New York are doing? And I think that was supposed to be intended to be strategic, right? Instead of saying we're going to come out strong and openly defy because we don't agree, I think the state stance was, we don't have to say we're defying anything because we're choosing to interpret our continued actions as lawful and therefore not in defiance of anything. So I don't know what that's worth, but I think it's a perspective that I think got missed, not because of the public's understanding, but simply because of what I believe to be ineffective communication.
Okay.
In a tricky time. I don't know.
Grant, and then Coach, and then Representative Arsenault.
I'm just reading in Vermont Digger that they they did kind of backtrack that statement, saying that superintendents, that the state would instead send out a single statewide certification. But like you were saying, Susanna, was that it was about, instead of trying to go defiant and argue, they wanted to give the superintendents a way of saying that they were complying with existing law and kind of continue their DEI practices, is what I'm reading now.
Coach? Floor is
Hi. I think the article does help to clarify what Susanna was, seeing. What bothers me and others is action.
Yeah.
And the action I'm concerned about is the response that the agency took with the reconstitution of the Hazing, Harassment, and Bullying Commission, where all of the people that look like me on this call were eliminated from the commission and any representation of that, when it was clearly identified by the previous three secretaries, being, Villaseca, um, the one before, and Rebecca Holcomb. Three secretaries ensured that we would not be seated in the balcony, but we could sit at the table. That is an action versus a mistake.
Absolutely.
And it
Yeah.
is being addressed by
Yeah.
a lot of folks. And I think it's something, I just had to say that for what it's worth.
Thank you.
I'm grateful you said that, because that was also something that feels like it came out of nowhere. And I also want to clarify that regardless of what happens with the current instance of the new, current threat of funding cuts and certifications or whatever, statewide telling people to continue what they've been doing on equity is not enough, because we already know that what the statewide places have been doing on equity in schools is clearly not enough, right? So that's not the standard we're trying to meet. And just like you noted just now, I mean, clearly we have a lot of really structural issues happening where they're creating and reviving structures that are not going to be reflective of what we actually need. So I'm glad you said that, and I'm not. I hope that I'm not coming off as being sort of an apologist for bad policy, because there's a lot of work we have to do.
Okay, thank you. Representative Arsenault?
Hi there. So I just wanted to add quickly that, of course, Susanna did a great job of explaining the situation as it's been explained to me as well. And something that helped me understand the issue really is that the instinct at the agency in this case was to put the responsibility and frankly the resulting potential liability on districts instead of shouldering that burden as a state agency. So that's where the concern is for a lot of folks in the State House, I think. Just knowing that was, I agree that it seems like this was as well intentioned as could be, I suppose. Like, hey, don't worry, you don't have to listen to, you don't have to comply because we already comply and we're going to say we comply with existing law. But to push that onto superintendents and individual districts rather than where they ended up, which is we will sign a single letter of certification as a state, is concerning. That it went first. The instinct was to first put that liability on individual districts is concerning.
I'm also concerned because there was a lot of gaslighting that went on this weekend and into today. That the concerns of BIPOC folks, and believe me, everybody who could was in a meeting on, I don't remember what night. There were 85 people there. A letter was written. A letter has been submitted with 85 signatories. The secretary also received 6,000 letters. Mind you, this went out in a memo on Friday evening. By yesterday, they had received 6,000 letters. And the phones apparently crashed. I mean, I called as well to excuse me? Because I had just seen the memo and I was like, this is really screwed up. And of course, I kind of work in TEI. So there was just a moment there. But I think what I found really problematic was the gaslighting. Oh, don't be so upset. What do you mean, don't be so upset? Seriously? I mean, I just, that's not an acceptable response. It's simply not an acceptable response. You don't say that to people of color, particularly at a moment like this. So even if it did work out the way you've all described it, and I'm perfectly willing to buy that, don't gaslight me. That still doesn't get us to, are we writing a letter or not? I'm hearing here that what would work best is that people do that individually if they're so moved, because I'm hearing on the panel different readings of the situation and such, and I don't know that we are gonna, I don't know where that leaves us as a panel, as a cohesive, singular, unitary body on this particular issue, which is moving very quickly, by the way. Just my thoughts. Anyone else want to come in here? Sheila?
Wow. Excuse me, I'm trying to make dinner for my parents.
Oh, I'm sorry.
No, you're fine. I'm just I'm having to multitask because it's pretty late already. No, I put out what I put out before. I appreciate people's knowledge
Okay.
of where we are right now, but I agree with, the comments that you're saying, Eitan, and sentiments that other people are saying that, there is doing something and it's how you do it. And so, and those are two different things. And so sometimes people have to attend to the impact, even if their intentions were different. And so I think that that is a piece of what is needed. But, my thing is just my biggest thing is not necessarily worrying about that. My biggest thing is making sure that we're moving forward with what needs to be done and that we don't go backwards. And so with that being said, making sure that we're strong and making sure we know where people are at, because the reality to it is people who are in that system, we don't necessarily have everybody who's like, woohoo, DEI, who's working in that system. And because of that, that has influenced, people are in different positions and different positions of influence throughout that system, and that can make or break certain situations. And I want to make it really clear to people who choose to be within our educational system in Vermont where our values are and where we stand. And so that is something that's important to me, so that our teachers, our administration, our systems can be effective because they know and they can stand by it. And it kind of reminds me of a conversation that I had 3 months ago with my staff when that guy got elected, and I said, what are we going to do? Because we're going to be under attack. We're not changing nothing at the root. We're not changing nothing. We're going to stand in our power. And that's what I wish other people would do. It's like people want to stand in that when it benefits them. But when it's a little wishy-washy or something might happen, it's like, oh, now you want to turn around, gaslight, do all the things. So the pressure, accountability is not on you. And I don't play that. And I know a lot of us don't either.
No. And it's really convenient that Reverend Hughes has his hand up because now we have public commentary. Mark? Mark? He's like disappeared.
Yeah, I'm still here. I'm sorry about that.
Oh, okay.
I was talking. I thought I was off mute. Shout out to Rebecca Turner. Also, with Sheila, what you just said, I just wanted to just lift that up and just first of all, just thank you for the work that y'all are doing down there, and it's good to be doing work that doesn't have to change. And as a matter of fact, that the work is actually, it just illuminates the necessity and just how important it was all of the time. And I can say some similar things about some of the work that we're doing up here. Eitan, I did want to go back to a question that I didn't understand because or the answer I didn't understand, because there was a question about the RDAP's path forward on the recommendations or on the I guess information received on the policies, probably about a half a dozen, which originated from the alliance. Of specific concern was the data policy and the oversight policy, which I can tell you more about later. But it sounded as if there was something that was going into executive session that precluded you from being able to answer that question.
Yes.
Kind of confused about that because
Mark, I can't say anything more about it. I'm sorry.
All right. So, but the question, just to be clear though, the question is what you guys were going to do regarding moving forward on any of those policies, right?
Yes, and it blends in with what will be
Gotcha.
discussed at executive session.
Fair enough. All right, thank you.
You're
So
welcome.
it's about as clear as mud. So
I understand that.
It's not I mean, it's not on you. You're doing what you got to do. Regarding the other piece that I wanted to talk about was just a little bit about the last conversation. I think as I think about the challenge, I think about the work of the Land Access Opportunity Board, for example, or the work of the Health Equity Advisory Commission and other entities across the state that are doing a lot of human rights, civil rights, racial justice, diversity, equity, inclusion, whatever you want to call it, work. There's a bottleneck, and it's not the state, the Secretary of Education, it's the governor. So I think that what we're not, the stuff that's not being said out loud is that the reason why there's not a whole of government approach on what it is that we're doing here is because of that. So I think if there's ire that's being directed, if there's discontentment or disappointment that's being directed, I think it's, in my personal opinion, Mark Anthony Hughes. I think unless it's directed to the governor, I believe it's misdirected because Zoe works for somebody and she's not a rogue. So I think that it would be probably more genuine and more impactful, and also more I think global in nature, because today we're talking about education, tomorrow we'll be talking about housing, and the day after that we'll be talking about the criminal justice system. Ultimately, at the end of the day, the buck stops with the governor in terms of any of these policies. I just wanted to just really emphatically just lay that right at his feet, because that's where the buck stops. And I don't think it's fair to the secretary, quite frankly. And I don't know her, and I would have never voted for her if I was a senator. And the chickens have come, roosters come home to crow, or whatever you say, however it's said. But because we saw this coming. But again, he appointed her, and she works at his pleasure. And at the end of the day, I'm quite sure she is not drawn outside of the lines.
Oh God, no.
So yeah, so it's just something to consider, panel, and also with the policy regarding, I'll go back to that policy, the policy regarding data, the Transparency Act. We were here last month talking about that too. Is I just wanted to just reiterate that it's kind of it's kind of a great overlay to everything that you've been working so hard for over the last 7 years. Because first it was the RDAP, and then of course first it was the ORE, and then it was the RDAP, the other way around, and then it was division, then it was the RJ-SAC, and then division of RJ-SAC came at the same time. But all of this has to do with racial disparities in the criminal and juvenile justice advisory panel, and in the work that you're doing. And now we're back to taking a look at a policy that would enable us to collect data across what seems to be almost the entirety of the remainder of the criminal justice system. And I think that's worth seeing a second time, a policy that gives us the ability to collect data across almost the entirety of the remainder of the criminal justice system, which is, at the heart of the ability for you to effectively do what it is that you do here as a panel. So I just want to strongly urge you to take the advice of your RJ-SAC,
right,
in taking it into consideration in supporting that policy, and working to cause it to come to fruition. I think the pushback that you were getting on it historically was, it's very predictable, and you got to consider the parties that pushed back.
right.
Of course, they're the parties that don't want to collect the data. So this is a pivotal moment, and I think maybe in the coming months we might be able to figure out how to advance it, at least in part. So thanks for the time.
Yep.
I appreciate you, and I hope you have a great evening.
Thank you. You too.
I just want to say, thank
We
you.
really okay. Go ahead.
I just want, sorry, Eitan, if I had a hand, I usually don't do this. I'm so
No,
sorry.
it's okay. It's just we don't have a lot of time, and I've got a lot to say.
So all I just wanted to say was that thank you, Mark. I really appreciate that. And we're called the root because we like to get at the root of things. So I really appreciate you inviting us to have a different direction of who we hold accountable and why. And
Yep.
I really like that. So thank you.
Thank you, Mark. Okay, at this time, I need to ask everyone who is not an appointed member of the panel or a legislator to leave the meeting. The information that I'm going to put out will be known shortly, but I need to speak first with the panel and legislators alone. So
Can I just
yes,
add, Eitan, just so folks are aware, the panel won't make any decisions in executive session. It's purely an information sharing about personnel.
Okay.
If I may just get clarification, delegates for appointed members, you're inviting to stay as well?
Yeah, panel members are what.
Gotcha.
So.
And media needs to not be here as
Right.
well.
Yeah,
Right.
media. So lovely person from Orca, thank you very much, but we need you to go too.
And it's anticipated we won't come back into session except
No.
to adjourn.
We won't. So I just wait. Okay.
I know that we're not really technical with Robert's rules and stuff, but
Well, that is technical, actually.
well, what I mean by that is my understanding is you have to come out of
Yeah.
executive order to be able to adjourn from your meeting. And if
Yeah.
we're doing it technical like that, I think we need to technically do like that.
We
It's
didn't
just-
do that because we only have 11 minutes left.
So I'm just going to put Orca in a waiting room, but to Sheila's
Okay.
point, I'll try and bring them back out of the waiting room to adjourn.
Okay. Where are we right now? I'm sorry. I'm like getting addled.
You want me to rephrase my
Coming,
question?
it's
No.
the technical coming out of
Right.
executive session and with no action taken.
No action was taken. Correct. Thank you.
That's having spent the last 6 months dealing with the open meeting law police. Yeah, that's the best
Okay.
way to handle it.
Can we go back into discussion for a moment, Todd?
Yeah, I think Rebecca restating what she said makes sense so that we can have that discussion.
Okay.
Right. Right.
Rebecca, can you repeat?
The question is to the panel members, what, if any, action we want to do, having heard a presentation earlier about particular bills, knowing that what we heard was that there were various stages of the process, some pretty close, some not necessarily going to be heard. Do we want to be proactive and ask for us to have a chance to testify or not? That was just a question. I was hoping the panel could weigh in.
And I'm willing to talk to Martin Lalonde because a lot of this looks like it's going to House Judiciary. And he's really good about getting us in and feels that it's important, which I think is significant. I will do that if people like. Do we want to weigh in on stuff?
Yes, I think so.
Okay.
I think that just so people understand, I think that what creates a barrier for me sometimes is that we have all this information, we have all these things, we had these bills that the RDAP was very interested in and had opinions or reviewed or whatever, and then we had the slew of what was presented today. And then for us to be like next steps and act on it, it's like me being like, okay, yes, but what specifically, which
Right.
ones are we acting on, and in what way are we doing that, just for clarification. So, you know, we had a lot of discussion, but it's like, okay, so is it this bill, we're saying these are the 4 bills and these are the points that we want to make sure we make? Or is it that these are the 4 bills, we just want to talk to those chair people and let them know that we want to be a part of the process and then get to that point? So that's just a clarity, because I feel like, how can I participate in this as a panel member? And I'm not positive what that looks like. And so I just wanted to be clear, if there was an ask, that I'm clear what my ask is.
I can ask you all to like pick a given number, let's say X number of bills that you yourself want to work on, and I can make myself a little spreadsheet and figure out which ones are like at the top of the list. I'm just guessing here, folks. I'm not saying this is definitely the way to go. I'm just saying I'm willing to do that, and that's something that occurred to me.
Another point I'm going to
Eitan, if you don't mind.
No, I don't mind at all.
I will also speak to Martin.
Okay, thank you.
If not tonight, tomorrow morning.
Okay, thanks a lot, Coach. Thank you for everything.
I think the decision on what we do here is really just based on what is the expected outcome. Is it so that we can get on the record taking a stance, or is it because we want to actually impact the trajectory of some of these bills? Some of them have already made crossover, and so if we are able to convince somebody to make changes, it would have to go back to the originating house. So if that's the strategy that we're looking to do for at least some of these, then that may impact how we approach it. We could say, hey, the RDAP, singular entity, wants to testify, or the RDAP, a collection of plethora of entities. We all have really big feelings about this and the weight of all of those entities. You know, maybe we all individually flood the gates to testify on these bills. I don't know. Or if it's just, hey, we want to register our discontent with something, but we don't actually expect something to come of it, then I think that's a lot easier, right? And that may just be a written submission or what have you. And that's a question we may have to answer for ourselves, and that may be on a case by case or bill by bill basis.
Okay. Rebecca.
And then there's also the other alternative, which is that we've been presented with a number of bills that have raised concerns of equity issues. And it's almost, you know, what we are doing through this proposed bill of, what are we calling it? I'm sorry, the assessment tool.
Equity is impact.
Right? In a way, using the ones we've just talked about that came up during this meeting to say, because we may not have time to substantively review and agree on as a panel, but at least that I hope we can say with these, we've been alerted that there are equity concerns. We're concerned that this has not been addressed at all during committee meetings.
I like that.
I don't know.
That seems realistic to me. Because I don't know. I think, Susanna, I think you're right. I mean, it's kind of late.
I concur. I think that's a really good idea, Rebecca. I think this presentation that we got today really is, it provides ample evidence in our support for what we have primarily been working on during this legislative session, which is the advancement of that equity impact assessment as a practice in the legislature. So I think kind of using this as the evidence for that argument, I think is really compelling. Today, what we looked at, I think it was good for orientation on all of us to understand what was before, but I don't think we went to the depth in any one of those areas to really have a group consensus or agreement on, or even a vote on. So I really like that as a plan.
Just another quick, technical, piece, and I'll call it a piece of it, behind the scenes administrivia. The biggest tool that any of us has access to is the let me just make sure I get this square for folks. The miscellaneous bills from any committee is the access point that can be used to create change. If the bill has already been moved all the way through, let's say, the steps, and it's between different houses, that culminating point again before the end of each session is the miscellaneous bill out of a committee. And we've done a lot of work, let's say, changing the flow or direction of things, utilizing that over the years. And I'm just throwing that out. And that doesn't negate taking the stand from the data that we were given tonight to move those forward that are still in play. So I'm just throwing that out there.
Okay. Why don't you, Coach, talk with Martin? And I guess what we'll do, because this moves so quickly, I'll send an email as soon as I have something. I think we may have to do this on email. Is anybody disagreeing with that?
I agree.
Okay. All right.
And I'm
So
not disagreeing with it. I just was going to jump and say, but the most important thing I think is to specify, not be so general. but to specify
Yes.
what bills we talked about. And I want to make
Yes.
sure that S87, and I know Todd, we are on different positions on it, but it did come up during the meeting. It wasn't part of that slideshow, but that it has been brought to the panel's awareness, these slew, and hearing coaches' points, which are well taken. Please don't underestimate that we are still very much in the game in terms of these things. And I know we all know this, but that to the extent and wherever they are, if there hasn't been a racial equity assessment on these, and these bills have come up to at our latest panel of concerns that these bills do raise these issues, please like hold the presses, or however we have said it. Eitan, I don't know, we're making recommendations to you, but this is not, we have beat this drum before.
Yeah, we have, and that's part of my problem. But
Can I
go
suggest
ahead.
the possibility of a special RDAP meeting? I need to think a little bit just from open meeting perspective on like, there's only so much we can do via email in terms of decision making. And so I don't want to make procedure control substance.
No, I understand. I just break the law all the time.
But I completely agree with Rebecca's point that we should be raising the fact that there aren't equity assessment impact on these matters. And at a minimum, we should be saying that for the legislator.
I could write a letter between now and the next RDAP meeting and bring that to you for edits, blah, 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 etc., that we could give to the chairs of perhaps 2 or 3 committees that are important and in play, and saying these are the bills we would really like to weigh in on that we see having a significant equity impact. And I'm willing to do that, but I also want to know from you all what those bills are.
Well, like, and I'm just thinking about like next month is May, right? Like timing.
That's the problem. And that's
I think I really like Todd's idea of a special meeting, and I know we're all tapped out with meetings, but that we should be doing that.
I'm tapped out with life at this point. I mean,
same.
So Todd, will you look into that and then get back to us because that we can do by email.
Yeah, we can definitely schedule the meeting. I guess while we're here and we're in the space, should I just aim for like a Tuesday? I got to remind myself both what's applicable and then how long the warning has to be. But I think a special or emergency meeting can be a shorter warning and blah, blah, blah. So
yeah, I think it's like 4 days or something. I can't remember exactly, but yeah.
So what we may do is just a poll to see when people are free to do a special meeting. And then the focus that special meeting, just so I'm framing it right, I'm not even writing while I do this, which is problematic because that's going to capture what we're doing.
We'll be focusing on what bills we want to talk. We're following Rebecca's suggestion and idea. Specificity. These bills we have identified as a panel have significant equity impact. We would like to have the opportunity to weigh in on these. I'd say it more elegantly, but it's after 8.
Okay.
My eloquence shuts off at about 8.
So whatever we say for the special meeting, it'll mostly be focused on what bills we want to raise equity impact concerns with the legislature over. And RDAP will then, through that meeting, figure out how we take a position or what we choose to do with those.
Correct.
Thank you.
Well then, thank you all for more than I can say. And I will see you all before next month. So, and we'll get this ironed out. We'll get this ironed out and push it on. So I always think of Jess Brown at this moment because I always got formal about adjournment. And there was one night where Jess was like, can we just go? So let's just go. Everybody have dinner or whatever, a drink. I'm having a drink. So Have a
Happy
good one.
birthday, Coach.